Okay, so where we left off, we were going to take up Oscar Pacheco. We were in the middle of doing that, but your client was moved to another location. So we're going to take that up very quickly. Who are the prosecutors on Oscar Pacheco?
That's me, Your Honor, Michelle Hayden.
All right, and hopefully everybody had a decent lunch. Okay. All right, let me see. Brent, I'm going to see if this is going to work.
I think I'm already on there.
All right, let's see what happens. Oh, it's working. All right, court is calling 2019 CR 12464, State of Texas versus Oscar Pacheco. Can I have parties announced for the record for the state?
Michelle Hayden.
For the defense?
Luis Martinez.
And are you Mr. Pacheco?
Yes, Your Honor. Sorry, I had to unmute it. I apologize.
No problem. We're proceeding by video because of the pandemic. Any objections from the state?
No, Your Honor.
Any objections from the defense?
None, Your Honor.
Mr. Pacheco, I'm showing you what's entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor, I did.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Judge, I have, and I did.
Court will find that the state is in compliance with discovery. Mr. Pacheco, I'm going to show you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
I did not review that one, Your Honor.
All right, Mr. Martinez, did you go over the bill of indictment with your client?
I did, and Oscar, that's just the indictment that says what you're charged with and what the allegations were.
That one being the misdemeanor you said?
No, that's.
All right, so let me do this. Let you go into a breakout room very quickly with him.
Okay.
Mr. Pacheco, if you could go to breakout room number 1.
Understood. Yes, ma'am. Yes, Your Honor.
Sure. Mr. Porter, did you need to speak with the prosecutor?
Yeah, I need to speak with Meredith briefly, Judge.
Okay, I'm going to send you to breakout room number 2. And Meredith is not here yet. As soon as she comes on, we'll take up your matter, but I'll send her to 2 once she zooms in.
Thank you, Judge.
You're welcome. Shannon Locke.
Good afternoon, Your Honor.
Good afternoon.
I'm here on Mr. Maynor, Jonathan
right.
Scott Maynor. I've conferred with Marcus.
Mhm.
I wanted to let the court know a couple of things. I don't know if he's present in the courtroom right now. I've been speaking to him.
He's not. The courtroom is empty.
Okay. I think I know the court's answer to these things. One, he told me that he was having some symptoms of COVID, scratchy throat and a cough. He does not have the results of a COVID test. I did tell him I'd let the court know. And he also asked me to ask for a continuance past the holidays, if that was possible.
Yes. So what we're going to do is I'll place you at the end of the docket to give you a chance to get your client here.
Okay, thank you very much, Your Honor.
All right, you're welcome. And Mr. Martinez will take your matter up as soon as I finish with this case.
Yes, Your Honor.
I believe my client is has the blue shirt on.
Okay,
Is there any way I could be placed in a breakout room with him?
yes.
Judge, this is Luis Martinez. He and Mr. Pacheco and I are back from the breakout room. And
All right, just give me a moment.
not a problem.
All right, we're going to go back on the record. And 2019 CR 12464. Mr. Pacheco, did you have a chance to review the document entitled True Bill of Indictment with your attorney, and did you understand it? You're on mute.
Yes, Your Honor, I do recall, Your Honor. Yes.
All right. Counsel, do you waive the reading of the indictment?
Yes, Judge, we do.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're proceeding on count 1, waiving count 2 and the enhancement allegation. And we're proceeding on the lesser included offense of assault, bodily injury, family in count 1.
Any objection?
No, Judge, there's no objection.
Mr. Pacheco, I'm going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all
Yes.
the appropriate places?
Yes, Your Honor, I did review it and I did sign. Yes, Your Honor.
Did you understand what you're charged with? The state is proceeding on the lesser included offense, rather, of assault, bodily injury, family. That's a Class A misdemeanor. The range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes, Your Honor, he did review it with me. Yes, Your Honor.
No, did you understand that?
Oh, yes, I
that's
did.
what the state is proceeding on?
Yes, Your Honor, I do understand.
Did you understand if you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement? If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor. That will not be.
Did
Yes,
you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
yes, Your Honor, I do understand.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, I did. Yes, I did.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor, yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge, I believe he is competent. I believe he was sane at the time.
Mr. Pacheco, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor, not in any way.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes,
Are you a U.S. citizen?
yes, Your Honor, I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, Your Honor, I did review it and I do understand it.
According to the plea bargain agreement, the state is pleading on the lesser included Class A offense of assault, bodily injury, family. They're waiving the repeater count. Punishment is to be assessed at 180 days in the Bexar County Jail. There's a $0 fine. There's an affirmative finding of family violence. There's to be no contact with Elisa, Eloisa,
Eloisa
Eloisa.
is how it's pronounced, I learned. Yes,
All right, Gracias, Graces. Did you understand with the affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
yes, Your Honor, I do fully understand.
Did
Yeah,
you
I
understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
If you can say that one more time, please.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as a primary custodial parent?
As a primary custodial parent, like I do have
Yes.
4 children of my own. But
And Judge, there's a previous finding, so that doesn't put him in any worse position than he was before.
Okay. So do you understand what I'm telling you, Mr. Pacheco?
no, I do not. I really don't, as far as.
Okay,
the
no
last part.
problem.
Mr. Pacheco,
you
what
can
she's
go ahead.
saying though is if you had ongoing custody battles, that this could affect you negatively. Do you understand that?
Oh, okay. No, sir, I don't have anything of that sort. My children have my last name and one of them is 21 years old, the other's 18.
Okay,
So you don't have any issues with that?
No, sir.
All
No,
right.
sir.
So do you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent? Did you understand that?
I now understand, yes, if I were facing a custody battle, it could possibly affect. Yes, Your Honor. Sorry,
That's
there's
either
no
yes or
voice.
no. Here's the thing, Mr. Pacheco. I'm asking you questions that require a yes or no answer. If there's
Yes,
something that you needs to be explained to you, let us know. So I'm going to ask you some questions. I need a yes or no answer. Do you
Understood.
understand with the affirmative finding of family violence, you cannot own or possess any weapons or ammunition? Yes or no?
Yes,
Do you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
yes,
Knowing all of this, did you understand that to be the entirety of the plea bargain agreement?
yes,
And knowing that, do you still wish to proceed with this plea?
yes,
Next, I'm showing you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it in both places?
yes, Your Honor, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Judge, there have not.
Then to the offense as charged as a lesser included offense on count 1, assault, bodily injury, family. How do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's no contest plea.
State offers
It's my
State's
day.
Exhibit 1 and its attachments.
And
All
that's
right,
without
any
objection, Your
objection?
Honor.
All right, Mr. Pacheco, I'm going to show you what's entitled Waiving Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor, I did.
All right, could I see parties in a breakout room, please? If I could see you all in breakout room number, oh, if you guys could go to number 3, please.
I was only trying to understand, Your Honor. I didn't mean to repeat it. Sorry.
Number 3, Mr. Martinez, please, and let me see.
You said you're on the 187? Yeah. 9829 600 2955. What really?
All right, so we are back on the record. All right, and the state offered into evidence State's Exhibits 1 and attachments. Any objections to that defense?
No, Your Honor.
All right, Mr. Pacheco, I'm going to show you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, I did.
Again, do you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, I do, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Judge, we've got an agreement, the state's offering 180 days Bear County Jail. Mr. Pacheco's been there for 162 actual days. We're asking the court to find the judgment satisfied.
All right, this is what the court will do. The court will follow your agreement. The court has found that there was sufficient evidence to find you guilty of the lesser included offense of assault, bodily injury, family. Court will set your punishment at 180 days in the Bear County Jail. There's an affirmative finding of family violence. There's to be no contact with Eloisa Gracias, and give you credit for any time served. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor, I did.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, I do understand.
Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, I do understand, Your Honor.
All right. And if you have a question on what weapons, the definition of the word weapon, you'll need to contact an attorney for that. Do you understand?
Yes, Your Honor, I do understand.
All right, we can go off the record. Mr. Pacheco, here's my advice to you.
Yes, ma'am. Fully.
One, sometimes people are not good at relationships. It takes work. Don't get into another relationship until you can keep an orchid alive and blooming for a year. And let me just tell you why the reason why I tell you orchids, and they're on sale right now at HEB for, I think, $14. The reason why I say the orchid is a very fickle plant. You can't move, if you move it too much, it'll mess up. Sometimes it'll bloom, sometimes it won't bloom. People at the office for Boss's Day bought me an orchid. I appreciate that to my staff. Thank you so much. I'm working on getting it to bloom again, but you have to have patience. If you cannot keep an orchid alive and blooming for a year, you're not ready for a relationship. And from reading that police report, you're not ready for a relationship. Here's the other thing. Eloisa and you that's not a good relationship. You're not allowed to contact her at all. That relationship is over. Do you have any children with her?
No, thankfully I do not.
Do you have any property with her?
No, I do not.
Do y'all own a home? Do you own a vehicle?
No.
So
at
there's
all.
absolutely no reason to contact her. You understand?
Understood, Ms. Boyd.
And
All right,
Judge,
good luck to you, Mr. Pacheco.
Judge, this is a short time relationship. Mr. Pacheco, he's got his issues, she had her issues. Court's absolutely right. They were not a good mix with each other. They were not a good fit. And Mr. Pacheco completely understands that, is mature enough to understand that at this point.
All right. And Mr. Martinez, are you going to help him get a orchid?
Judge, I'll be happy to get an orchid. Could we revisit that issue of JSAT? Would you consider JSAT not?
I really would, but he only has 160 odd days in. I'm sure, Mr. Pacheco, I'm sure they're going to release you and say it's a judgment satisfied, but I just cannot say judgment satisfied because you only have 160 odd days in. Okay,
So
but get an
Oscar,
orchid.
what I'm going to do is I'm going to contact the jail because they may have you giving you more credit than that, but that's what you have in actual days.
So being about the metaphor and the analogy about the orchid, I do get the overall thought and the gist and the idea, Ms. Boyd.
Okay,
Yes.
you don't want to find yourself spending a majority of your time in and out of jails or prisons, you know?
As
Mr.
far as,
Pacheco?
sorry, as far as there not being the judgment satisfied, does that mean that I won't be being released today, or can you?
You may.
I mean, there's a chance
you
that
may
you'll
not.
probably be released today. Do you want to speak with him in a breakout room, Mr. Martinez?
I very
Yes,
much hope
please.
so.
And then I can
All
get
right.
from there, Judge.
All right, thank you. Just have him come back to this room. Mr. Martinez, if you'll go back to breakout room number 3, and Mr. Pacheco, if you'll go to 3.
Understood.
Thank you.
Thank
You're
you.
welcome. Ray Martinez,
Yes, Judge.
you have your motion on Mr. Blunt. Is that correct?
Yes, Your Honor.
All right, we're going to take you up next. Mr. Tony Hernandez, who do you have?
Judge, from this morning, it was Mr. Williams was at the jail. I think there was some issue there.
All right, he is here now. Mr. Williams, can you unmute yourself, please? It's the longest key on the keyboard.
Judge, I don't think it's.
I-
All right, Mr.
got
Williams,
you.
how old are you?
Huh?
How old are you?
45.
All right, so here's the thing, Mr. Williams.
So,
I'm receiving reports. I don't take it as true, but I'm receiving reports that you're not behaving appropriately. Here's the thing, in this court, everybody is required to behave appropriately. If you do not behave appropriately, what's going to end up happening, because you know there's a shortage, we'll see you in 30, 60, maybe 90 days. So what I'm going to do, I'm sending you to a breakout room with your attorney, and he can discuss that with you. But I don't allow people to misbehave. This is not preschool. I'm sending you to breakout room number 1. Norma, can you let them send Mr. Williams to number 1, please?
Yes, ma'am.
And Mr. Hernandez, you can go to 1. Okay, I have 2 blunts. I have 14I and 17I. Why do I have 2 blunts on the screen?
He's sitting at 14.
14, all right. All right, and who is the attorney on the prosecutor?
Your Honor,
Michelle Hayden, Judge.
Okay. All right, and is Victoria Cruz on this as well?
She's my, we work together, Judge.
All right, Ms. Cruz, if you'll show your video.
Good afternoon, Your Honor.
Good afternoon. The court is calling 2021 CR 1783. This is the only case that I have the motion on. Is it only one case, counsel?
There's only one case, Judge.
All right, could I have parties announced for the record for the state,
Michelle Hayden for the state.
for the defense?
Raymond Martinez and Victoria Cruz.
All right, and are you Mr. Blunt?
Yes, Your Honor.
We're proceeding by video because of the pandemic. Any objection from the state?
No, Your Honor.
Any objection from the defense?
No, Your Honor.
Mr. Blunt, do you have any objection to this hearing taking place by video?
No, Your Honor.
All right, the court is in receipt of a motion to reduce bond from the defense. State, have you had a chance to review the defense's motion?
I have, Your Honor.
State, are you ready to proceed?
I am, Your Honor.
All right, is there an agreement on this motion or no? State, defense, any agreement?
No, Your Honor.
No, Your Honor.
All right, defense, it's your motion. You may proceed.
Judge, we'll call Mr. Blunt.
All right, Mr. Blunt, could you unmute yourself, please? If you will raise your right hand, do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, and if you could state your name for the record, please.
Kendall Blunt.
All right, are you able to hear okay, Brenna? All right.
I can hear.
Thank you. Defense?
Mr. Blunt, can you tell the court how long you've been in custody?
A year this week.
This week?
Yes, sir.
Okay. Is this your first and only arrest?
Yes.
Okay. In the past, when we've had bond reduction hearings, I've asked you about your financial status. I'm going to go through that again. Before I ask you the particulars, have there been any significant changes in your financial status since the last bond reduction hearing?
No.
Okay. Mr. Blunt, your bond is currently set at $495,000. Is that correct?
Yes.
Okay. And is it your understanding that the standard fee for a bond of that amount is $49,500?
Yes.
Okay. Mr. Blunt, do you own any real property?
No.
Do you have any money in the bank?
No.
Do you have any other assets that you could sell or borrow against to raise money towards your bond?
No.
Do you have any friends or family that have the means to lend you enough money to make a bond of $495,000?
No.
Okay. At the time that you were arrested, were you employed?
Yes, I was.
Okay. And what is your line of work?
I am a truck driver.
Okay. Is that employment lost at this point? Would you have to look for a new job?
Yes, I would.
Okay. What about a place to live? Do you even have a place to live in San Antonio at this point?
I can find one in San Antonio, but I do have residence in Texas.
Okay. So the place where you were living at the time that you were arrested, do you have access to that location?
No, I do not.
Okay. What about vehicles? Do you own any cars that you could sell or pawn to get money for a bond?
No, I do not.
Okay. So who has been assisting you up until now with attorney's fees?
My wife and mother.
Okay. And are you still lacking quite a bit of funds to even complete that fee at this point?
Yes.
Okay. If you were to be released on bond, would you be driving a truck locally or driving long distances?
I can drive locally.
Okay. So if you were released on bond and the judge put conditions like GPS, you'd ask that the court consider allowing you to work. Is that right?
Yes, I can follow those conditions.
Okay. I'll pass the witness, Judge.
All right, State.
Just a couple questions, Your Honor. Mr. Blunt, I wasn't the attorney at the last hearing, but you do not have any family members in San Antonio, is that correct?
I do have family in not in San Antonio, but in Texas, yes.
But not in Bexar County?
No, ma'am.
And most of your family lives in Florida, is that correct?
Yes.
I don't have any other questions.
All right, defense, any follow-up?
Just a couple. Mr. Blunt, you are a citizen of the United States, is that right?
Yes.
And you previously served in the military, is that right?
Correct. Yes.
And how many years were you in the military?
3 years.
And when you were honorably discharged?
It's a other than honorable, but general discharge.
Okay. But you weren't discharged for any bad behavior, is that right?
No.
It had to do with staffing and some issues about what your assignment was, things like that.
So come again.
Explain to the court what that means, other than honorable.
Other than honorable, it's not any like bad behavior, nothing like it's just a general flat out discharge.
Okay. That's all I have, Judge.
All right, State, any other questions?
No, Your Honor.
All right, defense, call your next witness.
Judge, I'd like to offer into evidence, I guess what we'll call defense exhibit number 1, which is the report from the expert witness appointed by the court to assist the defense. It's previously been disclosed to the state. I actually emailed it to her a while back when I got it from my expert. I didn't know whether I was going to be in the courthouse or not, Judge. I was going to hand carry one to you, have it marked. But
I do have one. Is this from Dr. Thomas? Is this the one from Dr. Thomas Young or no?
Yes, Judge. I actually left it this morning, so I'm real
All right,
rusty.
the court is in receipt of a letter from Dr. Young. And attached to that letter is a second document. Has the state had a chance to review those documents?
I have, Your Honor.
All right. And how are you offering them? Are you offering it as defense exhibit 1 and 2? Because I have it. I have the appendix, the logic behind the inferential tests. And then I have a letter from Dr. Thomas Martinez. So you're introducing both of these?
I don't necessarily need the appendix, Judge. I just need the 3-page. With the first 3 pages are basically his report.
All right. So, and this is defense exhibit 1?
Yes, Your Honor.
All right. Any objections to defense exhibit 1?
Not for the limited purposes of this hearing.
Right. And for the record, defense exhibit 1 is a document signed by Thomas W. Young, MD. And Brent, I'll make sure you receive this if you have not received it.
I have a copy, Judge, too.
All right, thanks. All right, anything else from the state by way of, for the defense by way of exhibit?
No, Judge.
All right, any other witnesses defense?
No, Your Honor.
All right, state?
Your Honor, we don't have any witnesses, but we do have a number of exhibits that we would offer into evidence for purposes of this hearing. And those have been emailed and provided to defense. The first one, State's Exhibit 1, is the autopsy done by our medical examiner's office.
Any objection to State's Exhibit 1, defense?
No, not the autopsy, no, Judge.
State's Exhibit 2, Detective Mulder, the lead detective in this case, for report.
Any objection?
No, Your Honor.
State's Exhibit 3, it's a voicemail left by Kendall Blunt for the victim in this case. I emailed it, but I can also have a copy burned to a CD after this hearing if you need me to.
All right, any objection?
Judge, I do object to that one. I've had this conversation with previous state's attorney. I think my objection is misleading, Judge, because I think that's time as to when that was recorded is very far from the date of the arrest. What I mean by that, Judge, is it's an old recording that's unrelated to the incident that occurred on the date of his arrest.
And Judge, we believe it's relevant for purposes of this hearing. One of the issues we have is we're concerned for safety of victims, the safety of the victim's family and the community. This was during the course of their relationship. They only dated for a few years. This wasn't something sent 20 years ago. He made threats against the victim in this case, LaTosha Green, and he made good on those threats. So we think it's very relevant and should come in.
All right, and then State's Exhibit number 4.
State's Exhibit number 4, Officer Zarate's report.
Any objection?
No, Judge.
State's Exhibit number 5.
Officer Avila's report.
Any objection?
No, Judge.
State's Exhibit number 6.
Officer Vile's report.
Any objection?
No, Your Honor.
So State's Exhibit number 1, 2, 4, 5, and 6 are admitted without objection. And then State's Exhibit number 3, the court needs to listen to it before I make a ruling on that objection. So if everyone will just give me a moment to listen to that.
And Judge, before you go to that, the state seems to agree with me that it's not close in time to the incident. Do they know exactly what the date on it is?
I don't have the exact date, but I believe they were only together, I think, 4 years total. So again, this wasn't something that was sent 20 years ago. It was something that victim's family member was easily able to find and provide on their phone. So.
All right, so just give me a moment. Let me listen to it, and then I'll make my ruling on whether or not that exhibit is admitted. All right, we are back on the record. The court has had a chance to review State's Exhibit number 3, and State's Exhibit number 3 is admitted into evidence.
And Judge, we had one last document that we emailed. It's not an exhibit, but it's a case out of Kansas, State v. Lyman, which actually it's another case involving a head injury where Dr. Young testified using his inferential test, and we would ask the court to review that case before rendering a decision in this bond hearing.
All right, defense, have you had an opportunity to review the case that the state is presenting?
Judge, I haven't actually read the case, but I think it goes more towards the weight of that you want to give to certain types of evidence. I don't think Dr. Young, anywhere in his report that I've offered into evidence, talks about this inferential method. Everything he cites in his report is directly out of the autopsy. He's not making up new facts or doing his own investigation. He's strictly citing what he reads in the Bexar County Medical Examiner's report. As the court knows, in these bond hearings, we're given wide latitude as to what is admissible. I don't think it's appropriate to impeach Dr. Young personally, which is what it appears to be what that case is for. I think his report speaks for itself, and I think it's really not useful for the court to get
Judge,
into whether.
I apologize, Raymond. Go ahead.
It's okay. I don't think it's useful for the court to get into questioning Dr. Young's history or his reputation.
Right.
Judge, the first page of Dr. Young's report that defense just admitted as their Exhibit 1, second paragraph talks about how his observations and opinions follow the inferential test. And that's what they provided that appendix for. So I do think it's relevant. This is a test that I've never heard of before. And I think that the weight that you give this evidence that's been provided by defense is important for purposes of this bond hearing.
Okay. All right. The court has reviewed state's case. The court will now hear argument unless there's other evidence to be offered by either side. Defense, any other evidence or rebuttal evidence to present?
No, Your Honor.
All right. Then the court will hear argument. Defense?
Judge, in reviewing Dr. Young's report, it's very consistent with what I think any layperson might think about when they read the autopsy report. They list the cause of death as homicide, but when you look at the allegations of whether it's choking or head trauma, the physical evidence, the physical markings on the body are not consistent with those allegations. And Dr. Young points it out very clearly in his report, starting with injuries to the neck, because in the police reports that the states admitted or offered into evidence, and the courts admitted, there was a suggestion that she was being grabbed by the neck or thrown around by the neck. Well, on page 2 in Dr. Young's, again, reciting what the autopsy report findings are, not his own conclusions or his own findings, but what the autopsy found. And a careful dissection of the neck revealed no hemorrhage or injury in that area whatsoever. The photographs indicated only 2 minor injuries, one to the upper eyelid and I think another one on the forehead. In this case, Judge, when they did the autopsy, they totally shaved the head of the deceased, and there was no visible scalp injuries whatsoever, which we have to consider that because when you look at the allegation that there was bleeding in the brain, that would normally be consistent with getting hit or assaulted in the head area, and there's no physical injuries in the scalp. The one witness who was present at the scene, the daughter of the deceased, in her own testimony, her own statement suggests that the deceased was still verbal and talking when she left the house. So there's no way to know whether or not a head injury occurred while she was gone. And then finally, Judge, most importantly, in my opinion, when they look at the bleeding in the brain, the doctor talks about the widespread distribution of the hemorrhage. In other words, we don't have a situation where there's a clear spot on the scalp or the head where the person was assaulted, whether it would be with an object or against the floor or against the wall. So, because if we had that, the bleeding would be concentrated in that area. It would be consistent with a trauma. The bleeding that we see in this case, as described in the autopsy report and in Dr. Young's report, it's thin and it's widespread, which could be consistent with an aneurysm. And the doctor talks about that. And that could be a spontaneous occurrence that's not necessarily attributable to trauma. And so while Dr. Young, in his conclusions, suggests that he can't determine with reasonable certainty what the cause of death was, he says, based on this lack of evidence, neither can the medical examiner's office. There's just too many unanswered questions that no expert's ever going to be able to come to a clear conclusion because we don't have physical injuries observable on the body. So, Judge, that being said, my point is this is a case where the cause of death is clearly very much in dispute. Mr. Blunt has never been arrested, never been charged with any offense other than this case. And so for that reason, I think a $500,000 bond is excessive. We'd ask the court to lower it to $100,000.
All right, State.
Your Honor, first I'll address defense's argument in Dr. Young's report. And in doing that, I'll refer to some of my evidence. I would draw the court's attention to Officer Zarate's report, where the injuries were listed out as the hospital. Just to name a few: bruised eyelid, abrasions to cheek, redness and bruising around neck, hematoma on forehead, redness to back of head. Some of these injuries are outlined in the autopsy. But one thing I'd like to point out about Dr. Young's report, he didn't even review the pictures from inside the victim's head. Now, those were provided to defense, and I don't know if it was an oversight, but he mentions there's no photographs of the inside of the head. And that is where the vast majority of the head injuries occur in these cases, especially when you're dealing with a subdural hematoma. Another thing I'd like to point out, he talks about Destiny Green, the eyewitness in this case, hearing her mother scream as she's leaving the second time. And I believe if you refer to the reports, it's Kendall Blunt, the defendant, that she mentions hearing him scream. He also did not review any medical records in this case. And then again, as I mentioned in that case I provided, he's using this inferential test that I don't think's relied upon by anyone else that I'm aware of in the field of forensic pathology. In that case I provided, which although it is a case out of Kansas, they're bound by Daubert and follow a similar standard for evaluating expert testimony. They basically found this inferential test to be junk science. So I would ask the court to consider that in this case. With regard to our autopsy, they did point out the external injuries as well as the internal injuries, and there are pictures of everything. So I don't know why those were overlooked. Dr. Feig and Dr. Kleesner collaboratively did this autopsy together. And this autopsy was also signed off on by Dr. Molina and Dr. Farley. Their signatures, as the court can see on the autopsy, are on the last page of the autopsy. And if there had been any dispute in their findings that this was a homicide or that the death was the result of blunt force trauma, their signatures would be lacking on it. There's no indication that this is any sort of death caused by natural causes. There's no evidence whatsoever of an aneurysm. The medical examiner's office was more thorough and based on sound scientific principles. So we would ask that you take Dr. Young's report and his conclusion with a grain of salt. Now, getting back to just the bond hearing in general, whether or not defense's quote expert can dispute findings by our medical examiner's office isn't really an issue to be considered in a bond hearing. The factors that we're most concerned about are the nature of the offense and the circumstances under which it was committed, safety of the victim and the community, and the aggravating factors in this case. So let's talk about that. In this case, it wasn't one strike on the victim. The defendant was assaulting her for minutes, as the court can see in the reports. Long enough for her 14-year-old daughter to leave, try to call 911, run back into the house, and leave again. This was a lengthy, brutal attack. And defense wants to act like there was some issue going on with our victim prior to this, but she's walking around talking. Everything was fine. And then when her daughter saw her again, she's unconscious on a stretcher being carried out. Now, as we provided in the reports, she'd previously, and the voicemail, she'd previously threatened the victim and her family. There's allegations in the reports where the defendant had laid his hands on our victim before, had laid his hands on other family members, and she in part left him because he was laying his hands on her. And he, as we mentioned, made good on his threat against the mom. Now we've got this 14-year-old out here there who witnessed her mother die and has been threatened by the defendant before. And we think there's a very real concern for her safety. Should he be able to make bond in this case?
All right, defense, it's your motion, so you have last argument.
Judge, whether or not my doctor looked at the pictures or not, he's a board certified pathologist. He read the description. He read what is described as a moderate global edema, which talks about how the blood is spread around versus being concentrated in one spot. So whether he looks at a picture or doesn't look at a picture, everything he's written in his report is based on the examination and the notes taken by the medical examiner. Judge, I would take issue with the suggestion that this inferential test was characterized as junk science. I didn't read the case. It's a Kansas case. It's not binding on Texas. I'm not sure it has anything to do with anything, to be honest with you. There is a question, Judge, in this case, whether or not there was an assault or there was a murder. There's a huge difference. A physical assault is a Class A misdemeanor if there's no weapons involved, and there's no weapons alleged in this case. And whether or not what ultimately led to the decedent's death is not clear, and I'm not sure it's ever going to become clear. If you read the reports and the autopsy, there are certain questions that are just never going to be answered. And so it's appropriate proof for the bond hearing for the same reason it's appropriate for the state to offer into evidence all of the reports of all the different officers. So again, Judge, we'd ask the court to reduce his bond.
All right, the motion for the bond reduction will be denied. Are both parties ready for jury trial?
Your Honor, I think both sides are still conducting some discovery.
All right, when is this going to be completed? Because I have from August 13th, we were called back for discovery on September 3rd. Defense was to provide, I guess, information from an expert. Both the state and the defense needed medical reports, or there were more medical reports. So where do we stand on that?
So Judge, I actually followed up with Detective Mulder last week, and I re-requested from the hospital the medical records from when the victim was hospitalized right after this incident. Detective Mulder was out of the office. She said she's back in today and she was going to work on getting me those items. I believe in talking to Raymond Martinez, there may have been some other records that he wanted to get. There were also cell phone downloads and a laptop that I believe were sent to Secret Service, which I think David Martin is in the process of copying right now.
Okay, so do we have the downloads?
I believe we do. He said he was working on those because he brought me the rest of the file. Other than that, I can check with him though. I know a lot of people were out last week because of the holiday.
Okay, so this is what we're going to do. Mr. Blunt, we're going to come back in December to make sure that your attorneys have everything so that we can start this jury trial at the beginning of the new year. All of the courts should have their jury trial dates by December, so we'll know where to place you, okay? But I don't want, of course, I don't want anyone going to trial if they all haven't told me that they have all discovery. But then again, we're not going to drag this out for discovery. And when I say that, what I mean is if the state or the defense, if you're not getting your discovery, then we'll set it for a hearing and subpoena whomever needs to be subpoenaed so everybody can get the information they're entitled to. So Ms. Ferguson, can I have a date in December for Mr. Blunt to come back? If we can have it in 2 weeks, please.
Judge, while she's doing that, if I could address your question as well.
Yes.
It is our understanding, Judge, that the decedent had some prior history of severe migraines and other issues in her head. And she was also in the military, so her records are probably, she was probably seeing military doctors, and I'm not sure the state has any of those records. And certainly that would be a relevant issue since we're.
Judge, we don't have any records and we don't have any indication that she had this issue either based on what I've seen in the file so far.
All right, so here's the question though. State, are you going to have access to her medical military records? Does anyone even know that she was in the military, Mr. Martinez?
I don't know if they knew, Judge. do you know?
I believe she was in the military.
All right, then the defense is stating that there should be medical military records, and I know the military, it may take a little bit longer. So if we could all check on that, and when I say if we could all check on that, I mean defense and state, to see where we are with regards to her medical records. So more medical records, and you all are saying that it's medical records as it relates to the complainant?
Yes, Judge, because there's obviously going to be a dispute about the cause of death. This is not a gunshot or a stabbing where there's no question there. There's a lot of question about it. And Judge, I know it seems like an old case, but if the court will recall, he was in custody for many months before the case was indicted. And then he was actually indicted without an autopsy. And we waited some more months to get the autopsy. So really, this case is probably about half as old as what it looks like.
Oh, no, I have it in my notes.
Okay, well.
Oh, yeah. But, you know, I have to make sure that people are working, everyone's working towards getting all the discovery.
Yeah.
So that's what we're working on. So we're going to come back. There are two choices for you all. I suggest December 13th because that gives everybody more time to actually start. I'm not saying that you'll have the medical reports by then, but at least start actively trying to get them. So December 10th or December 13th.
Judge, I think I'm in your court on the 13th, so that would work for me.
All right, so we're going to come back on December 13th, Mr. Blunt. And so you can realize December 13th is just the date for us to come back to see where everyone is on discovery. If there are some issues with discovery, then we're going to solve them at that time. If, lo and behold, miracles have happened and everybody has discovery from the military and everywhere else, then you'll be coming back on that date for a jury trial date. And I'm unsure state has an offer ever been tendered or no?
I don't believe so, Your Honor.
Not that I'm aware of, Judge, no.
Yeah.
All right. So Mr. Blunt, in this court, I require that the state tender an offer in all the cases. So they'll be able to tender an offer to you. And then once that offer is tendered, as you know, I always give people a plea deadline date, but I don't give a plea deadline date until defense has all the discovery. You understand?
Yes, Your Honor.
All right. If there's nothing else, we'll close the record on this case. Mr. Martinez, Ms. Cruz, do you need to speak with Mr. Blunt in a breakout room?
Sure, Judge, that would be great. Thank you.
All right. After you all finish speaking to him, if you could have him come back to the main room because we'll have to excuse him from here.
Understood, Judge.
All right. I'll send you all to breakout room number 2. And let me find you. There you are. All right, Mr. Porter.
Hey, Judge. Yeah, I'm wondering if they found my client yet, Mr. Gonzalez.
I think they have. Is this your client? Are you Arturo Gonzalez?
It's 14P, Judge.
All right, Arturo Gonzalez, raise your hand. Yes, he's here. Do you need to speak with him?
I do, Judge.
All right, Mr. Gonzalez, I'm going to send you to breakout room number 3 with your attorney.
Judge, I'm going to send you a chat.
All right, thank you. Okay. David Garcia, who do you have?
Afternoon, Judge. I've got Don Alvarado. Should be
Yes, ma'am.
CTD.
Right here.
Criminal Trial Division, okay.
I believe so, Judge.
I'm going to send you to breakout room
Yes, I'm
number
here.
4. A prosecutor will meet you there.
Thanks, Judge.
And Mr. Alvarado,
Yes, ma'am.
I've received reports that you're not behaving as well. So here's the thing. I'm putting you on notice. I'm not accepting anything as true, but here's the thing. I'm putting you on notice that if you behave inappropriately on Zoom, your Zoom privileges will be revoked. And as you know, there's a shortage. So we'll be seeing you in maybe 45 to 60 days. So if you don't want that to happen, you need to behave appropriately on Zoom. And the first thing you need to do is, because you're surrounded by other people and they gave you a mask, you need to wear it. And so just wait there comfortably. Your attorney is speaking to another, speaking to the prosecutor. Once he speaks to the prosecutor, we'll bring you to a breakout room with your attorney.
Yes, ma'am. Your Honor, just real quick. The only thing that I was, other than my masks, the reason I was behaving inappropriately was I was
Time out. Your attorney probably wouldn't want you discussing that with me, but what I'm telling you is, I'm not going to tolerate anyone being inappropriate on Zoom or being disrespectful. I require that everyone on this Zoom treats everyone with respect. I don't care if you're the inmate, the deputy, the judge, the prosecutor, the defense attorney, the probation officer. That's what's required in this courtroom. And if people are not being respectful to each other, that causes problems. It becomes an unhappy day. And then guess what ends up happening? People's Zoom privileges end up getting revoked. All right, Jonathan Maynard. Where is Shannon Locke?
Good afternoon, Judge Boyd. This is
Hi.
Kim Gonzalez. I'm announcing for Shannon. He may have had to hop off. So
Okay.
if our client is there, I'm here if we need to move forward.
All right, awesome. It's good seeing you.
You too, Judge.
Yeah. All right. Actually, I just received a chat from the deputy saying that your client went to the restroom and he's never come back. So,
Okay, Judge. I will reach out to him right now and see what I can find out.
all right. Thank you.
Thank you.
Hello, Robert Porter, you're back. You're on mute. I always mute you when you come out of the breakout room.
Why? Because you're afraid I'm going to be cussing and carrying on?
So what is happening on Mr. Gonzalez?
Judge, if you don't mind, I needed to speak with Meredith briefly.
All right. Meredith, I'm going to send Mr. Porter to breakout room number 5.
Okay, I'll meet him.
All right, thank you. It sounds like somebody just left the room.
No, sir. Yeah, copy of the defendant volunteer and explain itself.
So I have a feeling your attorney don't show up.
Should be able to talk. Yeah, the wrong. She already told
Hello, are you guys back?
She gave me a warning not to be
Shannon Locke?
wrong page or doing the wrong stuff, so basically I have to ask permission.
I'm back.
Hi.
Yes, ma'am.
Hi, where's your client?
He should be in the courtroom.
Is Mr. Maynard in the courtroom?
Yes, he is, Your Honor.
All right, so we have a contested hearing. So who's the state who's on this?
Mr. Sanders.
All right. Mr.
And so, Judge,
Savage?
if I could very briefly, Mr. Maynard isn't feeling very well. He tells me that he has symptoms of COVID, and he is asking that we get it reset.
Okay. State?
Yes, Judge, as far as if I'm okay with resetting it.
Yes. Or is the state ready to proceed?
We can be, Judge. I spoke with Shannon. He said it wasn't, or he didn't believe it would be contested. We do have our officer here just in case his client.
All righty. So the officer's here. So we're going to proceed.
Your Honor, could.
Yeah, if I
and
could
if-
have a minute to speak to Shannon, though, Judge.
Okay, sure. All right. I will send you all to breakout room number 2. Okay. All right. Victoria Cruz, are you all finished speaking with Mr. Blunt?
Yes, Your Honor, we are.
As always, it's good to see you in court. All
Yes.
right, Norm. You're welcome. Norm, can you let them know 14I can go back?
Yes, ma'am.
All right, David, where did he go?
Garcia?
Yes, there you are.
Afternoon, Judge.
Good
I
afternoon.
conferred with ADA Sanders. We may possibly have a disposition in 2 weeks, Judge. He's
Okay.
going to look at some evidence, and I'm going to provide some for him. And we may be able to get this case disposed of by dismissal. At least that's what I'm hoping. He says it'll take him about 2 weeks to evaluate everything, Judge.
All right, Ms. Ferguson on Alvarado, can we recall this in 2 weeks, please?
Yes, ma'am.
Your name is not Ms. Gonzalez. Norma Gonzalez, can we recall this in 2 weeks, please?
You mean Norma Ferguson? No, I'm not
Yeah.
Gonzalez. I mean,
There you go. Can you call it 2 weeks, please? All right, we're going to come back on December 13th.
Thank you, Judge.
All right. And Mr. Alvarado can be excused. He's 14G.
Yes, ma'am. Thank you. Apologies.
Have a great evening, Judge.
Thank you. You too. All right, and then Mr. Dow and Jose, what is your last name? 14F. Gonzalez? Is that your last name, Jose
yeah, I think
Gonzalez?
he was the other Gonzalez, Judge.
Where's his attorney?
I've left messages for everyone, Judge. Let me double check where he's at.
Thank you.
Here at the Bear County Jail.
Thank you.
They can figure out
He doesn't need to unmute.
Oh,
Yes, Mr. Boehner.
Yes, ma'am. Your Honor, if is Mr. Maynard still there?
He is outside.
Okay. I mean, as long as he's still there, Judge, I think we have an agreement. He'll need paperwork though.
Okay.
I'll check on it.
All right. Thank you.
Mr. Maynard would like a continuance, though, Your Honor.
Oh, I think once he finds out that there's an agreement and he's not going to prison, he may get a strike step.
Unfortunately, the agreement is that he go into custody for a short amount of time.
Oh, okay.
But so if we could get a continuance.
Right here in front, face to front.
All right, Mr. Maynard, I'm going to send you courtroom. If you could go to have him go to breakout room number 1.
Yes, Judge.
I'm sorry, number 2.
Okay.
All right, and Mr. Locke, if you and Ms. Gonzalez will go back to number 2.
On this one right here? Right here.
All right, Jose Gonzalez, your attorney is saying that he's having trouble logging in because there's a bad connection. He's out of county. So we're going to give him a little bit more time and see if he can make it in. If he can't, we're going to recall you for tomorrow, okay? So we shall see. All right, Mr. Locke.
Your Honor, he's saying that he's not feeling well enough to make the decision.
All right. Then I guess we'll be having a contested hearing because I don't have any doctors. I have nothing from him. I have him only saying certain things. So I guess we'll go forward with the contested hearing. So do you need to speak with him again, Mr. Locke? Or are we going forward with the contested hearing?
And so specifically, Judge, just so that he knows, I've asked you for a reset and you're telling me that that's not an option.
No, I mean, I don't have a doctor's note. I have nothing from him.
I can get it for you.
So where we are right now is we're set for a contested hearing today. The state says they have their witnesses.
They could hear you.
I'll take the plea bar.
So you'll, okay. So I believe he's willing. So when I've talked to him in the circumstance where you will not give us more time, Your Honor, he does want to change his plea to true and accept the 2-year recommendation that the state has made.
Okay. I mean, that's completely up to both parties if that's what they want to do. All right. So Ms. Ferguson, if you can get the paperwork to the defense, please.
Mr. Ryan, can you go back to your regular, breakout room, please?
All right, we're just waiting for the paperwork for your client, Mr. Locke.
Your Honor, we're waiting for Mr. Lockheed to go back to break room number 2, I believe.
All right, Mr. Locke, if you can go back to your, to breakout room number 2, please. Mr. Dow, we're waiting on your attorney, Mr. Rocha. If we're not able to get in touch with your attorney, we're going to recall it for tomorrow, okay?
All right, I understand.
All right, but we're working on it.
No problem. I've given you a lot of mercy and try to be as honest as I can with you.
Oh, well, I appreciate that. Honesty is the best policy. At least that's the rumor.
So far, with my experience with you, it really is.
Oh, well, thank you.
Your Honor.
Yes.
Mr. Manor is stating that he can't get up, he's dizzy, and he can't go over the paperwork.
Oh, well, I guess we're going to go forward with the hearing. And actually, we don't need a consent from him to plead by video because he's present in courtroom.
Just wanted to.
Okay, do it from here.
All right, so we'll go forward with the contested motion to revoke.
He changed his mind.
I'm just.
Okay.
Now watch this. Look at this.
Well, all right then. To the court, please let Mr. Maynard know that at 3:39 p.m. At 3:42 p.m., we're having a contested hearing. So anything that is going to be signed, we've been here waiting for him since 2 p.m. It should have already been done. Norma, I'm going to place something in the chat box for you.
Yes, ma'am.
And Mr. Torres, we're trying to get in touch with your attorney as well.
I chatted you back, Judge.
Thank you. All right, so Mr. Dow.
Yes, ma'am.
Jose Gonzalez and Mr. Torres. What we're going to do is we're going to recall your cases for tomorrow and see if we can get your attorneys in. Mr. Dow, we are waiting to hear. Let me see. On your attorney. Just one moment. All right, Mr. Dow, and your attorney, we're waiting to hear from him. So we're going to recall it for tomorrow at 9 a.m. Mr. Jose Gonzalez, your attorney is out of county and there's something wrong with his Wi-Fi. So he's probably in a smaller county. No disrespect to smaller counties, Brenda, because I love small towns, but the Wi-Fi may not be what it should be out there. And then Mr. Torres, we're going to recall you for 2 p.m. Your attorney, it's possible there's been some miscommunication because you have 3 other cases as well, okay? All right, so we're going to call you all back tomorrow at 9 a.m. and have your attorneys here.
Judge,
Yes,
the docket's gonna change. It's gonna be at 1:30 tomorrow.
I'm sorry, 1:30 p.m. Tomorrow at 1:30 p.m.
For
Yes.
all of us.
for all
All
of
right.
you.
Thank you, Your Honor.
All right, thank you all for your patience. Have a great rest of your Monday. Wait a minute, don't leave until the court coordinator calls and lets the deputy know that you're excused. Otherwise, you'll get in trouble.
I have a great day, Your Honor.
All right, well, thank you very much. I appreciate that.
I called them already, Judge.
All right, thank you. So you all can be excused. Sure, come on back.
Thank you.
Sure, just 1 second. All right, you are back. And I have documents that I am signing. Okay, everybody is ready on Maynard? All right, Marcus, are you there?
Judge, is in your chat.
What's your birthday, John?
Okay. All right, Robert Porter.
Hey, Judge. I was just gonna chat normal real quick. I think my guy still needs a certification of a right to an appeal.
Okay.
I don't see one.
All right, is this going to be a sentencing? Is this a plea?
It's gonna be a plea and it's gonna be prison time.
All right, is it Arturo Gonzalez?
It is.
Yes.
All right, what I see in the form that was given to me, it does say consent and certification. And that's for 2021 CR 6595. Are there two cases?
There are, but
No.
that's what he's pleading on.
Does it show his signature?
Yes.
No, he must have blew right past that one.
Okay.
Okay, then, yeah, I guess we're ready, Judge. And just for the court certification before he gets in here, some of the paperwork is wrong. And so the state is going to have the corrections made when we get on the record, okay?
Yeah, Judge, there was essentially a new agreement, but in order to save the court some time, it would require Your Honor to just make a change.
Okay, sure. What would I be changing?
So there's not going to be a deadly weapon finding.
Okay.
Would not be checked. And then instead of a cap of 10, no app, it's just 9 years.
All right. The clerks will swear him in and I'll make a change to the plea agreement.
Okay. Thank you,
Okay.
Judge. And also
just-
we are, oh, sorry. We
I was just
don't need a
gonna say
PSI anymore.
Yeah, no, it just because where he does his plea to it, it also has that the enhanced weapon finding also, that's going to be scratched.
Okay. All right. I'll take care of that.
Thank you, Your Honor.
You're welcome.
Do I need to bring him in or y'all going to bring him
No, they're going to swear him in one of the breakout rooms.
Okay.
So they're actually in that breakout room now. Just give me a moment.
Shannon, I sent the chat.
Fall down the stairs and you break your.
And you can take these back. Are we ready on Maynard? Or no?
Yes, Your Honor.
Oh, let me see. Deputies, are we ready on Maynard yet or no? We may not be ready on him just yet.
Sorry, Judge, they're still talking to
So
him right now.
your,
They're
with your
trying
blood
to get
pressure
him
just
to the
being a little bit.
Okay, all right, thank you. Okay, just give us a moment on that. So we're gonna go on Arturo Gonzalez. And before we go on the record, Brenna, I just need to change what both state and defense said is being changed.
And then Judge, under the judicial confessions and admissions part,
Mhm.
to have that deadly weapon paragraph in there, so obviously that would be struck.
And so the cap of 10 is going to be changed to 9 years?
Correct.
And there's no affirmative finding, correct?
Correct.
And then in the waiver portion, no deadly weapon allegation?
Correct, Judge.
And where else are you all requesting the change?
I believe just the part that has judicial confessions and admissions, the paragraph. I just have count 1 and then.
Just one moment, I'm sorry.
Sure.
All right, Mr. Locke, Mr. Gonzalez. My understanding is there's really not a reason for your client to go to the hospital, but just out of the abundance of caution, the deputies did call someone. And because there's no reason for him to go to the hospital, but he's requesting himself to go to the doctor. I'm gonna allow him to go. He's requesting it. And they have to take him because he's requesting. But immediately upon his release from the hospital, which I assume he's going to get there, they'll probably release him in like 20 or 30 minutes. He's coming back to court tomorrow. So Mr. Maynard will be here tomorrow at 1:30.
Very good, Your Honor.
Okay. And State, if you could have your witnesses here for the contested tomorrow, please.
Yes, Judge.
All right, so it will be a contested hearing tomorrow at 1:30. And Deputy Laura and Ms. Ferguson, can you make sure that Mr. Maynard gets his paperwork to appear tomorrow at 1:30 for a contested hearing?
Yes, ma'am.
Thank you.
May we be excused, Your Honor?
Yes, thank you.
Thank you, Judge.
You're welcome. Have a good one.
You too. Bye-bye.
Bye. All right, so I've changed everything on Mr. Gonzalez's paperwork, so we can proceed with that. The court is going to call 2021 CR 6595, State of Texas versus Arturo Gonzalez. Can I have the parties announced for the record, please? For the state?
Meredith McIntyre for the state.
For the defense?
Robert Porter for Mr. Gonzalez.
And are you Arturo Gonzalez?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objections from the state?
No, Your Honor.
Any objections from the defense?
No objections, Your Honor.
Mr. Gonzalez, I'm showing you what's entitled defendant's consent to appear by video. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Gonzalez, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney and did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
Your Honor, the state is proceeding on count 1, waiving the remaining counts, also waiving the deadly weapon allegation and the habitual offender enhancement allegation.
No objection.
All right, Mr. Gonzalez, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Did you understand the state is proceeding on count 1, which is possession with intent to deliver a controlled substance, penalty group 1, 4,200 grams. That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, I did, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine or confront any witnesses that the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, I do, Your Honor.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, I did, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Gonzalez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, I haven't, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, I am, Your Honor.
Are you a U.S. citizen?
Yes, I am, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm going to show you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, I did, Your Honor.
According to the plea bargain agreement, the state is proceeding on count 1 only. They're asking that your punishment, and you've agreed that your punishment will be assessed at 9 years in the prison. There's a $1,500 fine. State will take into consideration 2021 CR 6596. Did you understand that to be the plea bargain agreement?
Yes, Your Honor.
Defense, is that the plea bargain agreement?
It is, Your Honor.
State, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, I did, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged in count 1, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State, any evidence to support the plea?
State offers State's Exhibit 1 and all attachments.
Any objections?
No objection, Joe.
Mr. Gonzalez, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, I did, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, I did, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we respectfully request that the court follow the agreement.
All right, the court will follow your agreement. The court will sentence you to 9 years in the prison. There's a $1,500 fine. Time and money will run concurrent. Taking into consideration 2021 CR 6596 and give you credit for any time served. Next, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney and did you understand it?
Yes, I did, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, I do, Your Honor.
All right, and because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, I do, Your Honor.
If there are any questions about what a weapon is, you'll need to contact an attorney for those questions. Do you understand?
Yes, I do, Your Honor.
All right, Mr. Gonzalez, good luck to you. We can go off the record. Mr. Gonzalez, how old are you?
50 years old, ma'am.
All right, you're getting to that point unless you're planning to live past 100, where more of your life is behind you than in front of you. I can say that I'm in the same shape. More of my life is behind me. I don't know if I really want to live to be 120. If I do, I hope I'm in good shape where I can still be independent. But you need to ask yourself, do you want to be going in and out of prison, in and out of jail? I mean, is that the life you envisioned for yourself when you were in elementary school?
No, I didn't, Your Honor.
So it's, if there's a drug or alcohol problem that you're dealing with, you got to get help for it. Nobody can help you if you don't reach out.
Yes, ma'am.
Because otherwise,
understand.
what's going to end up happening is you're going to go before maybe some judge, some other prosecutor, some other defense attorney, and you may find yourself doing a life sentence at the prison. And then you know what's going to happen when new people come to the prison. They're going to say, how are things run? And they're going to say, ask Grandpa Gonzalez. They're going to say who that is. That's Arturo, right?
Yes, ma'am.
And you don't want to be in that situation, because when you're in that situation, then you're going to be telling all the young people in to change their lives. Some of them are going to get smart with you and they're going to say, well, why do you change your life? So don't be that person. Come out and do better, be better. All right?
Yes, ma'am.
All right. Good luck to you, Mr. Gonzalez.
All right. Good luck to you, ma'am.
Number 14P can go back. Thank you, Mr. Porter.
Thank you, Your Honor. May I be excused.
Yes. Have a good one.
You too. Bye-bye.
Bye-bye. All right, the last person we're waiting for is Tony Hernandez. Do we know what is happening with Mr. Williams? I think that's the last one. Let me check. Yes, Mr. Williams is the last one. Let me go in there and see what's happening. I'll be right back, everyone. All right, your client didn't come with us. Ms. Ferguson on Mr. Williams.
Yes, ma'am.
I'm gonna need a reset date, and we're gonna reset this. Let's reset it. We'll see where we are at the end of December, Mr. Hernandez. Is that enough time, you think? Oh, you're on mute.
Yes, Judge, and if we can work something out before then, I'll let the court know.
All right, Norma, on Mr. Williams, can we set him around December 15th?
Yes, ma'am.
All right, so we're gonna see you back on December 15th, Mr. Williams.
Thank you, Judge.
Yes,
All right,
ma'am.
you're
Yes,
welcome.
yes, ma'am. Thank you. And I'm sorry about the mishap earlier, Judge. All right.
That's okay. You know what my motto is? Know better, do better. If you
Yes,
know
ma'am.
better and you
But-
don't do better, that's a problem.
But
So
I didn't do,
appreciate
but
it.
I didn't do anything.
Hey, I appreciate it. Norma, can you let them know 14E can go back? All right,
Thank you, Judge.
Mr. Hernandez, thank you so much.
Thank you, Judge. Take care.
All right, you too. All right, everyone, we are actually done for today. And so we're going to stop live stream. Where is Marcus, who's usually here, and Brittany and Meredith? Brenda, this is like, what is that they used to do on Romper Room, where she'd hold the mirror and tell all the little children that she saw, although you guys are not children. It's just a memory, my childhood memory from Romper Room. Who is behind you, Meredith?
Brittany and I share an office.
Oh, wow. Look at this. I'm getting like stereo.
I know, it's kind of.
Oh, that's awesome. Yay.
Yeah, it makes Zooming kind of interesting, so we have to plan around it.
Oh, okay. All right. Well, we're going to stop live stream, and we're going to be back tomorrow actually at 1:30 p.m. instead of at 9. So let me stop live stream.